Welcome everyone. I'm Nikki Jovicic from LookUpStrata. Today we're joined by Tim Graham from Bugden Allen Graham Lawyers to specifically talk about the upcoming changes to the Victorian legislation due to commence on the 1st of December 2021. Please note any legislation mentioned during the session will be specifically referring to Victorian legislation. Tim has a presentation in a short while and then we'll move into the Q&A section of the session. Before we begin, I'd like to mention that the information contained in this session, including the discussions that arise from submitted questions, is not legal advice and should not be relied upon as legal advice. You should seek independent advice before acting on the information contained in this session. Let's get going and see what changes are coming and what you need to do about them. I'm delighted to introduce our panelists today, Tim Graham from Bugden Allen Graham Lawyers. After more than a decade as a partner of HWL Ebsworth Lawyers, Australia's leading independent law firm, Tim joined the partnership of Bugden Allen Graham Lawyers in June 2021. Tim is one of Australia's preeminent strata lawyers and he's internationally renowned. He's president of the Australian College of Strata Lawyers and a fellow of the college. Tim is also a council member of Strata Communities Australia National and SCA Victoria. He sits on the Property Law Committee of the Law Institute of Victoria. Tim has been recognised by his peers and numerous local and international awards, including Best Lawyers in Australia 6 times, and in the Doyle's Guide as a leading property and real estate lawyer and leading litigation and dispute resolution lawyer. Tim is a keen educator and presenter. He's guest lectured at RMIT, Deakin University and the University of New South Wales. Tim is published regularly in the Australian Property Law Bulletin and is a member of the Bulletin's editorial panel. He authors the Owners Corporation chapter of the Lawyer's Practice Manual and wrote the case study update for Subdivisions with the Lot. Tim runs the Victorian office of Bugden Allen Graham Lawyers. Since 2017, Tim has also been a contributor to the LookUpStrata site, and collectively his articles receive thousands of reads a month from our Victorian audience. Welcome, Tim.
Nikki, thank you. Good morning, everybody. Obviously, the barbershops have been open in Victoria since we last spoke, so hopefully Peter Black keeps his requisitions about my beard to a minimum in your questions. So thank you once again for the opportunity. I note that our august CEO has got yesterday's date on. I think there, Nikki, he was aspiring to WA time, or at least to be closer to you. So my apology for that. But as I say, thanks for the opportunity. And it's the aspiration of this paper. Can you just confirm, please, Nikki, that you can see my shared screen?
I can, and it looks great, Tim.
Okay, fantastic. Now all I need to be able to do is to use the arrow key and we should be all right. It's the aspiration of this paper. There's obviously a lot of information going out about these changes. Most of it, from what I've seen, is just really replicating a narrative. I aspire to go a bit further than that and put some context around it, some analysis, and hopefully some practical application tips and traps. The commencement of that process, I thought I'd start with just the acknowledgement that it's almost 14 years since the Owners Corporations Act came into operation in Victoria on New Year's Eve in 2007. And that was the first significant legislative change we'd had since the Subdivision Act in 1988. So things moved pretty slow, although not quite as slow as WA. What we did have is 12 significant amendments during the course of, or the currency of the Owners Corporations Act. They tended to stop a couple of years ago whilst attention went to formulating the amendments commencing in 3 weeks. But I've just got there for reference. And the point to be made, I think, is this. It's an ambivalent one. On the one hand, I suppose we should commend legislature for the Owners Corporations Act being a significant watershed amending moment, but it has been monitored with some acuity, and that has manifested itself in this range of amendments as it's gone. So that's probably not a bad thing that legislature has proven itself to be flexible and reactive, although one might equally say that if they got it right the first time, there wouldn't need to be so many of these amendments. When the body corporate review was, for those that were around all those years ago, remember that expression, body corporate. When that review commenced in the early 2000s, this nomenclature came into all of the material and issues paper in a final report, and it just kept making the comment that the one-size-fits-all regime under the Subdivision Act was no longer appropriate, having regard to the exponential increase in the number of OCs, or bodies corporate, and their increased complexity, taking into account range of uses and those sorts of things. Unfortunately, what we got to recognise by way of enshrining that proposition that a one-size-fits-all approach was inappropriate, what legislation gave us by way of regulation was simply a dichotomy that an owners corporation is prescribed if it levies fees exceeding 200 grand per annum, or if it consists of more than 100 lots. That's the benchmark, and if you prescribe, the compliance requirements are more onerous. If you're non-prescribed, they're less. I don't take the view that that really did anything to reflect the one-size-fits-all approach under the Subdivision Act was inappropriate. And I think I'm fortified in that comment. If you just have a look at nationally what the situation is, I won't go through this in any great detail, but I'll just note that in Queensland, where I think it's done the best, there's the umbrella legislation in the BCCMA, and then there's 5 modules under that, which are a regulation, and they have regard to the different uses of a development. So it seems to me it's completely fictitious to judge compliance requirements on the amount of fees levied or the number of lots. The needs of the and the dynamics of a complex really depend on its use. So there's obviously things are pertinent to a high-rise tower that won't be relevant to a lateral greenfields estate. And so I think we've unfortunately missed the mark a bit. All of the other states, or most of the other states in the ACT there, they differentiate between community titles, which are lateral estates, and towers. So I think Queensland, the level of detail Queensland devolves into is applaudable. All other states at least recognise the difference between the types of OCs. We didn't, judging it by income or lots, and what we've now gone for is this 5-tier system, which is purely based on lots. So the amount of fees levied is out the window. As Nikki said in the introduction, the legislation commences on the 1st of December. Now, my inquiry, that's 3 weeks away. My inquiries tell me that 3 weeks is right about the time it takes to develop a habit. So I think we're timely commencing today, and if you're to spend the next 3 weeks diligently encapsulating yourself in these amendments, there will be a habit by the 1st of December. So very well done, and hopefully it's not an easy habit to break. But anyway, so the 5-tier system, in the first iteration of the amending act, it was a 4-tier system, and tier 1 was up to 50 lots. And there was 2 references then in the body of the legislation that referred to a tier 1 OC of more than 100 lots. After working that out with my calculator, it seemed to me, well, you know, why not just call 100 lots something else? So through SCA, there was a bit of lobbying, and we achieved an outcome there, which is a good one. I think, unfortunately, it's a missed opportunity that we're basing compliance requirements purely on size. It has nothing to do with the range of uses and the different characters of owners corporations. But guys, it's not changing. So this is what we're going to habitually apply ourselves to. They at least did something in recognising there's this notion of a services only owners corporation. And if you've got a services only OC, it will be deemed a tier 5. And that is if there is no common property and no common services, it's a services only OC, which seems a little bit oxymoronic. If there's no services, it is a services only OC. But anyway, and we've got the difference between occupiable and non-occupiable lots. The easiest way, I think, to approach that is if it's a primary lot or a residential or commercial. If it's the primary, it's an occupiable lot. Non-occupiables go to car parks, storage lockers, and those sort of things. That differentiation is probably well known to Victorian managers, at least, who have started paying their SCA membership based on the amount of lots managed, and they don't take into account, with some exception, non-occupiable lots. So there's probably some practice going on in that space already. Okay, into the substance of it. This is a really quick one. The requirement for a common seal has been dispensed with, and there's our common seal. Hopefully he doesn't go the same way as the rubber stamp. Of course, seals were completely archaic and anachronistic. As long ago as 2001, the Corporations Act did away with the need for seals insofar as companies were concerned. So I guess 20 years after that, we're getting with the times. This might also be worth noting that there's a lot of documents that have always been able, or any document has always been really, I think, able to be executed without a seal. Sure enough, the Act says that an OC executes a document by using its seal, but that's not exhaustive. There are other ways that a document can be executed. For example, by a person, whether it's a manager or a chairperson or whomever, having delegated power. A delegate can sign on behalf of an OC and bind it, and a delegate won't have a seal. So this probably just reflects what's really always been the case. There's a new provision in regards to water on common property, and the thing hasn't come into operation yet. As it does, and as cases unfold, it will be interesting to see how this develops. But my forecast is that it creates a little bit of nuisance, because what the section says, if that any water touches common property, it's OC responsibility. Now, that might just be a trite motherhood statement, but it could have an unintended consequence. When you juxtapose it with Section 16 of the Water Act, says pretty simply, if water flows from property A to property B and causes damage, then A is liable to B for the quantum of that damage. The new section says, so you may just say that. There may just be, well, if common property is property A, water's gone from common property into a lot, which is property B and caused damage. That's consistent with the Water Act, and maybe that's what it says, but the syntax of it to me looks to go a little bit wider than that. And I think it makes the owner's corp responsible if water touches common property at any point in the chain. The OC is liable. So an OC may have increased Water Act exposure that doesn't currently exist, given that. Let's see how it unfolds. It's good to be aware of it. I couldn't resist including the case of Spagnolo. This is the one where a couple of mates hired a service department, and they went out on the gas. One of them came home early, turned the spa on and promptly fell asleep, and the spa overflowed. Insofar as water left that lot and caused damage into other lots, there was clear Water Act rights. But insofar as water from the spa caused damage to the actual room in which the spa was located, there was number 609. There was a lot of discussion about whether the Water Act test had been met. Had property flowed from property A to B, or had it flowed from A to A? In the event it was A to A, and the Water Act didn't trigger because the water originated in the lot and caused damage within the lot. But the arguments were from the Applicants Council that the water actually started at the Sylvan Reservoir, I think it was. At least they stopped short of saying it commenced in the celestial heavens. But it's a good case to be aware of. Just to tell you mind, that fundamental test for the Water Act to apply, water has to flow from property A to property B unreasonably and cause damage. As to how, in the case of an owner's corp, Section 17A might change that, we're now on notice. This is, of course, the best amendment and it's easy to bring legal proceedings now. So we've still got an OC mustn't commence legal proceedings unless it has an authorised resolution, but the exemption currently is for recovery of fees or enforcement of rules. You don't need a special resolution. It seems to me that that is probably extended, certainly in the event of money. If the amount of the claim is under 100 grand, which is the Magistrates Court financial jurisdictional limit, an ordinary resolution is okay, and therefore, assuming the committee has all the usual delegable powers, then the committee can authorise it. So that's all right. I think the mischief here may lie in if the claim is for a non-financial amount, is it within the jurisdictional limit? And enforcement of rules won't usually be about money. My suggestion is that it is, that if the claim doesn't relate to money, then it is within the jurisdictional limit. It's certainly not outside it. But anyway, the legislature hasn't really done us wonders there. And just the point at the bottom there, we've been grappling for a long time now with authorising orders where a lot owner goes to VCAT and seeks leave to sue on behalf of an owner's corporation. My immediate instinctive reaction when I first read this was that those might be less, given that it's going to be easier to issue proceedings, it seems. The need for individual white knights to go down and pursue their own frolics in some cases might be less, but I don't think that's the case, because 165 1BA, I don't have a slide for it, but there's also an amendment there that comes out, and a presumption is created that a person seeking leave will be given it unless some respondent that opposes it can establish on onus that leave shouldn't be given. So it's almost a rubber stamp for individuals to be bringing proceedings on behalf of an owner's corporation. That makes a lie out of the whole notion of certainly a special resolution, but any kind of resolution really. And what business is it of one owner to go and be pursuing relief and potentially bearing cost and cost exposure on an OC's behalf? Anyway, that's what we've got. There's a new what I've called a new benefit principle. This isn't a bad one potentially, although I think it's open to abuse. So an owner, we know currently that fees are based on liability, and that the only exemption to that is if the benefit principle applies, and it's a really limited exemption. I know there's still a lot of misunderstanding around it, but for the benefit principle to apply, it can't apply to annual fees. It can only apply to special fees. It has to relate to repairs, maintenance, or other works, and those works must wholly or substantially benefit some or one, but not all of the lots. So you've got to tick all those boxes for the benefit principle to apply historically. As from the 1st of December, the OC, if it's incurred additional costs, can on-charge the owner. Now, I think it's a really good thing. You don't have to grapple around with the benefit principle and misapply it. If the OC has incurred additional costs, they can be charged to the owner. It will work retrospectively. I don't think you can't charge the owner prospectively because the OC hasn't incurred those additional costs yet. But I think so. So there we go, and it does extend to insurances as well. Excess amounts or increased premiums resulting. Let's just move a bit slower here. You've got to make out this test. So an OC can pass on increased excesses or premiums to an owner, a lessee or a guest, provided that they result from or are attributable to an insurance claim, obviously, and if the claim is caused by a culpable or willful act or gross negligence. All those words are pretty high up the scale. Gross negligence is higher than mere negligence. So if an owner, occupier or guest is negligent, you can't pass it on in the event of insurance claim, but if they're grossly negligent, you can. So there's obviously going to be, and culpable and willful really mean, close to intentional. Anyway, that's A, and then in regards to damage to common property, that's wide A. You don't have those strict tests. If damage occurs, then the cost can be passed on. So we applaud that, I think. There looks to be a lot of detail in this slide. There really isn't. All it says is tiers 1, 2, and 3 must prepare financial statements in accordance with Australian accounting standards. It's optional for tiers 4 and 5. Australian accounting standards is given a definition in the Associations Incorporation Reform Act. And basically they're issued by the Australian Accounting Standards Board. Well, what does all that mean? The Australian accounting standards apply to reporting entities, and reporting entities are typically, things like companies that have duties to shareholders, and shareholders have a right to see where their money's going. I don't think an OC is a reporting entity. Yes, it's got lot owners who have a right, I suppose, have a right to see where their money's going, but to the level imposed by or the need to prepare a general purpose financial statement, to me, is overkill. All it's going to do is increase the amount of money OCs need to spend on these things, and it won't give any increased security. If someone wants to defalcate, they can still defalcate irrespective of whether a general purpose financial report is prepared or not. And look, as we know, a lot of purchasers don't read their contracts. A lot of their advisors don't have sufficient knowledge to advise them properly. Putting that level of information is just creating more complexity and confusion on the part of purchasers that don't read the documents anyway. But that's what it is. I understand that a lot of the software providers are probably working overtime on making sure their products discharge the requirements of the Australian accounting standards. I can't say anything about that. I haven't looked at it. I don't know. And I'm not an auditor or an accountant anyway. But I just say that to flag in advance. I think, will our system be able to manage it? Talk to your provider. In terms of auditing, tier 1s must be audited by an auditor. Tier 2 must be audited by an independent accountant. 3, 4, and 5 don't have those auditing requirements, but they can opt in if they choose. Audits must be in writing. Maintenance plans, tiers 1 and 2 are required to have them. 3, 4, and 5 are optional. We've still got the question that if a 3, 4, or 5 chooses to have a maintenance plan, is it bound by the statutory mechanics of it, or is it really a sinking fund using the old nomenclature and they can spend it on other things and they're not wrapped up? I suspect it's the latter. If you can opt in, you can opt out. But I do concede and confess that could be met with arguments that having opted in and owners having made their financial arrangements to meet the necessary contributions they make, it's not a matter of capriciously jumping in and out all the time. That question's been around forever and it just hasn't been addressed. So that question remains. The only point of the last slide, which has got nothing to do with the amendments for the 1st of December, but it's just a reminder because it didn't always exist. The 18 regulations require maintenance plans to cover all those things set out there. Before those regulations, when you look at the OC Act, all it talks about is heating and cooling plant and elevators. They're the only things that have to be included. That was picked up by the regulations. We've got that level of detail, and it was obviously always good practice. If you're going to spend money on maintenance plans, you might as well include anything of any import or significant gravity in terms of amount to be included. I just concluded that as a reminder that those things must go in. There's a really interesting one here. I think subsection 2, a lot of owners mustn't prepare and maintain common property and services. It's the OC's responsibility, quite obviously. And to do so is a breach of the rules. So I think we've got really a motherhood statement at subsection 2. And the 7Co case I've referred to right down the bottom there, that just says that if an owner goes ahead and carries out work, they can't look to the owner's court for reimbursement of that. But they shouldn't be touching common property because altering or damaging common property or obstructing it is a breach of the model rules, as we know. And most of your OCs that will have registered special rules will go a lot further than that in terms of what you can't do on common property. But the really intriguing one, it's paper for another day, but I couldn't help myself. I apologise. Subsection 1 says that subsection 2 is subject to section 56 of the Equal Opportunity Act. And that is just alarm bells start going about Black's case. And in about one short minute, you might recall that Black's case, an OC was found to be a service provider because the public can enter upon common property as a service provider under sections 44 and 45 of the Equal Opportunity Act. The owner's corporation must not discriminate in the provision of goods and services. So the general prohibitions in section 44 and 45, which were found in Black, I've got the VCAT reference there, but the Supreme Court agreed on appeal that 44 and 45, the general prohibition on discrimination applied to owners' corporations because they were service providers. Section 56 talks specifically about owners' corporations, and the sections are quite different in what follows. I'll go no further than that for present purposes on the substance and the differences, but it just struck me as really intriguing that the parliamentary draft person has made it very clear that the prohibition on a lot owner repairing and maintaining or ordering common property is subject to section 56 of the Equal Opportunity Act. But it hasn't said that it's subject to sections 44 and 45. It's irresistible, therefore, for me to entreat you to agree that the parliamentary draftsperson has concurred with me that VCAT and the Supreme Court got the Black case wrong. Sorry for that. Disposal of goods on common property. Well, really good intentions. There's never been an easy answer to this. So many times I answer questions about dumped cars. There is a manager, I won't humiliate, but a manager in the eastern suburbs once told me in the event of a dumped car, they've got a phone number for a bloke called Bob, and all you got to do is call Bob and Bob will look after it. If you wanted to pursue your avenue legally, strictly speaking, well, what you'd have to do is go and get an order to remove things. And, that costs money and takes time. What we've got now is the OC can dispose of goods abandoned on common property, but it's got to give notice first. And it seems to me that if you know the person, abandoned vehicles, you won't be able to give notice because you won't be able to find the owner. And if you know the person who owns the abandoned good for the purpose of giving them notice, then you probably can cause them to move it without the need to rely on this section. There are provisions I haven't gone into great detail. I've just cherry-picked the interesting parts of this. And the second point there is that if an owner's corporation can dispose of a good, before doing so, it must, or may, I should say, move the goods onto a safe place if they're blocking reasonable access or if a reasonable attempt to locate or communicate with the person who abandoned the goods. I reckon that's an oxymoron, but anyway, has been made. And look, okay, but what's a safe place and who pays and all that sort of stuff. I think there's still so many obstacles to the triggering of these sections. You might find it actually is more streamlined to just go and get an order outside the operation of these sections. Or if you've got a bloke named Bob, give him a call. The applicant for registration of a plan of subdivision who appoints a manager prior to the first meeting of the OC. Well, that management contract expires at that first meeting. This has been ripped straight out of interstate legislation. They've got it spectacularly wrong because a manager cannot be appointed before the first meeting. What happens is the proper linear sequence is this: sometime around the date of practical completion of building, well, maybe not, I'll withdraw that. A plan of subdivision goes into the titles office and gets registered. If that plan creates an OC, and almost always they do, but They don't have to. Then the OC comes into existence automatically once that plan is registered. Typically, the inaugural annual general meeting is held within days of registration of the plan, and it's at that inaugural AGM that developers, whilst they still own usually all, or at least a significant majority of the lots, make resolutions to enter into contracts and do all sorts of things. That's when you would appoint a manager at the first meeting. There is no mechanism. I guess they could run a ballot, but I've never seen that happen. So there is certainly no orthodox mechanism by which a manager can be appointed prior to the first meeting. I think they meant the first meeting after the developer is no longer the majority owner. And then we've got, there should really be an update on the second bullet point. There is a prohibition on or a proscription on contracts being entered into exceeding, oh no, I've got it there, sorry, exceeding 3 years. A Rama, I think it was very successful in lobbying government and getting hotel and resort management contracts excised from the operation of that proscription. So hotel and resort management contracts, which are Queensland management type, management rights type arrangements, can exceed 3 years. Any other contract must not exceed 3 years. And that creates all sorts of problems, I think, but we're going to turn our mind to ways around it. And the most immediate one that presents itself is leases. That oftentimes leases are a linchpin of, then it might be a power generator or plant equipment. You might lease to City Power, so they've got access and these sorts of things. Those leases need to be long term. Indeed, they need to renew really for the lifetime of the building. Better network infrastructure, things like this, that 3 years in duration just really makes them impracticable. We'll test this, but my first argument is that leases aren't contracts. This talks about entering into contracts. My suggestion is that a lease isn't a contract. A contract is a private right. A lease is a proprietary right. A contract is not transferable, a lease is. So I reckon there's a cute argument here that doesn't apply to leases because they're not contracts. But if you want to avoid that argument, one way of doing it is just to have a 3-year lease with 10 options of 3 years exercisable at the sole and unilateral discretion of the lessee. I think another thing that was missed here, and I need to wrap up so we can get into questions, so I'll move pretty quick with your blessing, that an initial owner, the developer can't be appointed as the manager, and that extends to associates, which are employees, family members. That's never what associates are in practice, is it? If a developer entity has a management entity, you're going to be talking about companies, and companies haven't been prohibited. They're not defined as an associate. So on the pure face of it, it seems to me that it just doesn't touch. You don't import your spouse or domestic partner or sister or child or dog as the manager if you're a developer, do you? It's going to be an incorporated entity, and they just haven't caught it. There are new duties on the part of managers. The most interesting one, I think, is there at D, that a manager must take reasonable steps to ensure that goods and services procured by the manager on behalf of the OC are procured at competitive prices and on competitive terms. I'm going to unpackage that a bit in the next slide. I think E's motherhood, you must not exert pressure in order to influence the outcome. That you can exert pressure, but not in order to influence the outcome. And I don't think managers are in the business of exerting pressure. Managers are in the business of making recommendations and reasonably advising their owners, corporation clients. That's not pressure. But even if you push pretty hard, that this is the only engineer that can do this job, in my experience, all the rest rubbish. I still don't think that's pressure because I don't think it influences the outcome. There is obviously, you can't put a gun to someone's head, but I think exerting pressure literally is almost that far up the scale. Just unpackaging a bit, reasonable steps. So the duty is not strict or absolute. You just must act reasonably in the circumstance, and that's going to depend on a number of things. If your owner's corporation is in the middle of the hinterland, it doesn't have, and there's only one lawnmower in a 500-kilometre radius, then I don't think you have to get a second quote from a lawnmower that far away. If you were looking at a structural engineering issue and the building may blow over, well, yeah, sure, 500, you might have to look overseas. It's all going to depend on the circumstances, but I wish to make this point plainly. It does not require managers to get 3 quotes. Other states do that, and it's a real problem because you might not have 3 recommendations. If there's only one engineer that can do the job satisfactorily, just throwing up a second and third recommendation for the sake of giving 3, they're not your recommendations. And the corollary is also true. You might have a lawn mowing matter where there's 10 different people that can do the job equally well. You don't have to get 3. Just be very clear on that. You have to take reasonable steps. Procured to me means that you an exercise of discretion. The word is synonymous with obtain. But if you're directed by a committee that we instruct you to engage Tim Graham of Bugden Allen Graham to perform a certain task, then you're just doing what you're lawfully told and you've got no discretion as a manager. I don't think that's procuring on behalf of the OC because you're just doing what you're told. I think for this to trigger procurement connotes some exercise of discretion. And in terms of competitive prices on competitive terms, I think that's just really taking reasonable steps, but it doesn't mean the cheapest. And oftentimes, as you know, you compare scopes of work, they're not apples and apples, they're apples and oranges, etc. So price is a factor. I'm not trying to say it's not, but it's one of many factors. Competitive price does not mean you go with the cheapest quote, if indeed you procure more than one, and you may not. The restriction on proxies, unfortunately, we got that if you can only have one proxy, if there are 20 owners or less, and then 5% if more. Same applies to powers of attorney. We did get a regulation, and the regulation, funnily enough, provides a conduit to carving out industrial or commercial, industrial, I think. I better check that before we're done, but OCs may not be subject to this, but it doesn't really enact it. But look, there's a real problem. Quorums are difficult to achieve. There is not one case in the 14 years that VCAT has been hearing these disputes, there is not one case that has been decided on the basis of proxy farming. I know it happens. There's actually nothing wrong with proxy farming happening. If it maximises attendance at a meeting, that's not a bad thing. There is a problem if those proxies are procured on the basis of misrepresentation or fraud, or they're used in a manner other than utmost good faith. But there's no cases on that. So you've got to assume that the Section 89 protection on demanding or requiring proxies to be given is working. And for government to come in heavy-handedly and say that and put these limits on is just going to frustrate the process even more, I'm afraid. I'm just going to jump to my final slide. I think I've taken a little bit longer than I'd intended to, probably when I got distracted by the Supreme Court getting it wrong in Black's case. There's new provisions for entitlement and liability. If the plan is creating an owner's corporation, it must specify the details and be accompanied by a statement detailing how entitlement and liability is allocated. You expect those statements to say not much, just that the surveyor that fixed them as she or he thought was reasonable and appropriate. Say but accept it, but further guidance is given further down, and liability in the plan. It creates a presumption that liability must be allocated equally unless there's a substantial difference in size or there is different lots have a bearing on different differential consumptions of utilities and their cost and number of occupiers in each lot, which really goes to size. And I think they're all linked in this. I think so. One and three, I think, are about the same. That the larger the lot, the more people, excuse me, it can accommodate, and the more people a lot accommodates, it's reasonable to assume the more consumption of utilities there's going to be. So that's all tied up. But so I don't have changes too much. I think that's good practice. Those are the things we take into account when we're applying a VCAT to amend entitlements and liabilities. And VCAT found in Conroy's case all these years ago that I think the legislature's ripped off VCAT's decisions, frankly, because we had expert evidence that went to these things, and the tribunal decided in our favour. And now, 10 years later, we've got the legislature encapsulating it in statute. So it's not a bad thing. An entitlement must be based on market value. The word market is the new and interesting part to that. Because entitlements always had to be based on value, but it didn't say what value. And it seemed to me that the real test probably should have been reinstatement replacement value, because if you look at it this way, we're talking about lot entitlement. In the event of a total loss and the insurer cash settles, the cash settlement is dispersed amongst lot owners according to their entitlement. And the value of insurance is based on reinstatement replacement. It's not based on market value. But what we've got here is that a surveyor is a disconnect or a non sequitur, because the surveyor is charged with the obligation of allocating entitlement on the basis of market value, whereas insurance valuations and potential insurance payouts are based on reinstatement replacement. So I think that was probably a bit of a gaffe on the part of the legislature also. Nikki, I've gone a little bit over time, so let's speak quickly with your questions.
That's fine, Tim. I'm sure everyone can sit and listen to you all day. That was wonderful. Thank you so much. I think two things I learned. I think we timed the session really well with your 3 weeks out, so everyone's got that 3 weeks of practice, so they're fine. And the other thing, everyone needs to still have someone called Bob.
That's yes. Just don't tell me about it, please.
That's it. We don't know, but
precisely.
Okay, that's great. If I can just get you to unshare your screen now, if that's okay.
Oh, yes, of course.
That's right. And we'll jump into the Q&As. So we had a few that came through, which were fantastic, and I've copied down some that have just come into the chat while we've been talking. Okay, first one we'll jump into. This one's from Geeta. Committee members' duty of care under section 117. How does an OC manage out consistent breaches as they bring on their buddies and spend dollars when they should not be spent?
Well, it's really, if you want to allege, firstly, let's look at the duty. The duty is to act honestly in good faith, due care and diligence, and not make improper use of the position to gain advantage directly or indirectly, financially or otherwise, for the committee member or any other person. I think the word improper is the key to all of that. I think as a committee member, you can be as conflicted as you like. So you can certainly bring your mates on, but you just can't act improperly. So I think the bringing the mates on probably isn't really the linchpin to it. But if money's being spent, for example, to benefit those people, or a minority of people, or those sort of things, that probably does tick the improper box. That's the necessary box to tick, and it would be actionable. So it's really a matter of going to VCAT and suing. You'd have to name the OC because the committee is the delegate of the OC. You probably join the committee members in their interesting capacity. We might talk for an hour one day about whether in Victoria committees are a separate legal entity or not. We won't do it now. But anyway, the short answer is you go to VCAT, but just be... allegations about breach of duty are made against OCs and committees and managers all the time. As soon as someone in an OC does something that someone else disagrees with, they allege breach of duty. The duty is a lot higher than that. So I'm not seeking to dissuade you if that sort of conduct has been going on. unsatisfactorily, by all means, you've got VCAT at your disposal, but just look at it in a measured way.
Okay, wonderful. Thank you. Okay, we had one from Joyce that came in. Will strata managers and OCCs be able to view the utility safety checks required by this legislation to validate that all residents covered by the OC insurance policy are compliant? What authorities are in place for investors, leasing agents to comply with these required checks? And will the resultant checks be certified or just to tick a box items with no standing if a subsequent incident occurs?
I'm going to have to be selective on how I deal with that because there's a hell of a lot in it. So I'll do that this way. I didn't have a slide, but there is in legislation now the documents that a developer must hand over to the owners corporation at the inaugural annual general meeting include warranties and an asset register. So if the documents that the question identified are documents that would fit, and an asset register is not defined. If the documents of the kind the question goes to are included within the definition of asset register, then the developer must give them to the owners corporation. If they sit outside, then there is no obligation. If the OC has them, they're entitled to be viewed by any lot owner, including and other classes of persons, including committee people. But as to whether an OC has them will depend on what the developer gives them or what they can potentially procure from council, etc. I think that's the best I can do, given the detail in that one, Nikki.
Okay, wonderful. Thanks, Tim. We've got one from Shelley. If an unanimous decision is reached that lot owners will individually insure their property, is the owners corporation required to have public liability insurance?
The amendments don't go to that, so I might just take that on notice if I can, and I'll come. Can we circle back to that one? It's just not something that's fresh on my mind because it's not part of the amendments.
Okay, that's fine. We'll leave that one for now then. That's great. Roger, the developer of our apartment block retained ownership of an underdeveloped lot, which was registered on the plan of subdivision with one lot of liability. Within 6 months, he had developed the lot into 2 penthouse apartments, but never registered the further plan of subdivision with the new lot entitlements of 535 each, thereby avoiding OC fees of $250,000 over a 10-year period. Local council said they could not force the developer to register the new plan of subdivision with the new lot entitlements, as did the Victorian Building Authority. The Minister of Consumer Affairs would not say who was the responsible authority, and the matter had to go to VCAT to be resolved. Can this manipulation of the system still occur under the new legislation?
Certainly don't ever rely on CAV with the greatest respect for probably anything, certainly not legal advice. They wouldn't know. VCAT is the appropriate place to have a plan amended. This is really, I think, our last discussion, Nikki, but so VCAT can amend a plan absent a unanimous resolution if it's fair to do so, and those amendments may include an OC disposing of or acquiring common property and altering entitlements and liability. So if you've got a situation where the entitlements and liabilities, it sounds on the example, are purely or they're awry, they don't properly reflect. Entitlement's supposed to reflect value. Liability is supposed to reflect what is a just and equitable contribution to the resource of the OC. In other words, it's a user-pay system and you put back in what you take out. That's how they work. It seems on that example that clearly has not happened. So VCAT, I would have thought, with one liability point seems laughable, and I expect that VCAT would agree. But I suppose Consumer Affairs got that right. The application needs to be made to VCAT under Section 34 capital D of the Subdivision Act, and VCAT will readily make changes, amending a plan of subdivision, including entitlements and liabilities, if it's satisfied that it's fair to do so. That's that one, Nikki, and I've got your answer for the antecedent question. The question goes to section 63 of the Owners Corporations Act, which says, by unanimous resolution, an OC may resolve that if there is no common property, each lot owner must arrange the lot owner's own insurance. So it can only occur if there's no common property. And if there's no common property, you don't need public liability insurance. So if you do have common property, you do need public liability insurance, and section 63 can never apply. Lot owners cannot unanimously resolve to arrange their own insurances if there is common property.
Excellent. Thanks, Tim. All right, that's fantastic. Thank you so much. Do you want another question, or you'd like to, you're happy to wrap it up there? Or
no, I'm in your hands. Do you want to do one more?
All right, we'll go. Here we go. We'll go to the ones that were submitted just today. What are your thoughts on the maximum time frame of 14 days for special resolution ballots, considering most ballots are not resolved within the historic 28-day time frame? That was from Michael.
If I've understood that correctly, that we've got an interim resolution. Notice of that interim resolution must go out within 14 days, and within 28 days, then a person can call an SGM, which effectively stops the interim resolution in its tracks. Is that long enough? I can certainly see benefit in, I mean, you've really got a 14-day window, right? If the minutes don't go out for 14 days and you've got to call or seek to call an SGM to stop the interims becoming final within 28 days, you've got a 14-day window to do that. I suppose, look, there's going to be factual scenarios, doubtless, where that time is tight, and if you're, if you've got 1,000 lots with a significant representation of investor owners that live extraterritorially, then it's going to be very difficult to try and engender that support in that time. But the other side of the coin is the interim resolution's passed. So insofar as people did attend that meeting, there's more in favour on it than aren't. And you can't wait forever for an owners corporation to get on about its business. It has recurrent obligations to discharge. It's got to pay its bills. It's got to insure itself, and it's got to carry out repair and maintenance and do these sorts of things. So I think the longer you wait to advantage the person that wants to try and overturn an interim resolution, you're putting an OC in a precarious situation of not discharging its obligations. So I think the balance is about right. But probably the real nub of the question, to my mind, goes to the types of, there should perhaps be a differentiation between a shorter period for things that need to get done. So generation of fees and payment of invoices probably work on the extant model. If you're talking about hiring and firing, entering into or terminating significant service contracts, things of that nature, I could certainly see some benefit in a greater period of time. So it's an interesting one. But yeah, I think that's the best answer I can give. I think it's about right. I can see the difficulty it causes. In a perfect utopian world, we probably have a situation where it depends on the business of the interim resolution as to what time period should apply.
Okay. Thank you. We had a quick one. Good morning. Do the changes to Victorian legislation make reference to OCs where owners are interested in selling their block, i.e. the percentage of owners who need to agree to the sale? That was from Yvonne.
Unfortunately, no. In my opening, Yvonne, it's a great question. In my opening, I made the point that I thought there were a lot of missed opportunities in this legislation, and that's one. It just, they've gone into so much detail about you know, what contracts come into, and I didn't have a slide for this, but it's pretty well known, the disclosure of any beneficial relationship on the part of the manager if you're going to receive a commission or other benefit. There's just so much regulation and proscription tied up in those things, which is really not necessary because, again, there's a dearth of cases where that's ever occurred. Philosophically, I'll say that, you know, government is informed by the government department, which is Consumer Affairs, and Consumer Affairs is the entity that receives consumer complaints. So it's looking at it from bottom up, not top down, unfortunately. And that's what drives policy. Anyway, back to the direct question. No, it was just completely ignored, as were a lot of other things that really should have, you know, important issues. There's a lot of distractions in this legislation about minor or superfluous nugatory points. We had the model of New South Wales went in at 75% 5 years ago. There's different regimes around the world. Everywhere is trending towards something less than unanimous. And it just didn't get mentioned. It's ignored completely. There's no change. Unfortunately, I'm very critical of that, if that is not already palpably obvious. But you do have VCAT. So in the same way that VCAT can order, I just made the comment a moment ago that VCAT can order the amendment of a plan absent a unanimous resolution. The same applies to termination of an owner's corporation. So, and I've got one running at the minute that I'll be able to report on one day, hopefully. Well, if we win, of course. So we'll see. But look, VCAT on its face, VCAT's there and can make that order. Unfortunately, the legislation ignored it, and it's lamentable that it did so.
Okay, thank you for clarifying that. And also we had we're probably two more. I think we had a few questions come in around this issue, but this one sort of summarises it. So I might just ask you this one from Chubb. If a lot owner makes an insurance claim which affects the premium and that lot owner pays a higher portion, what happens when the lot owner leaves? Does the higher premium then rest on the next owner of the lot?
That is a spectacularly good question that legislature didn't think of, and nor I. But yeah, look, because excesses relate to a specific claim, so they're sort of one-offs, whereas premiums, excuse me, once they're increased, probably stay increased. I think the language of the section. You could, I don't know the answer, but the legislature didn't turn their mind to it. My instinct would be the purchaser doesn't inherit that. For a liability to run with a lot and to survive transfers, you need an express statement, I think, to that effect. Whereas the language of the section we looked at talks about a lot owner causing that increase. That is an individual person. It doesn't talk about a lot owner or its successors in title. So it seems to me what it really implies is that a lot owner, so long as they are, and probably by that definition, they have to be a lot owner for the section to apply to them. If they're no longer a lot owner, they don't. If the purchaser, I don't think the purchaser inherits liability because the section doesn't say so. And the section does seem to put it on the specific person that caused it. So fantastic question. I think where you end up is that lot owner has the burden of the increase for the currency of their ownership, but upon disposition of the lot, the excess doesn't change, but the OC picks it up. I think that has to be the answer, based on what's written, but it was obviously not something that was considered discreetly.
Very interesting question.
Yeah.
Okay, and then just last one, if we can. This one was from Julia. Could you please clarify changes to numbers on an OCC?
Yeah, thank you. Good question. It's the result is going to be the same. The current situation is a committee must have a minimum of 3 and a maximum of 12 members. and it's perfectly lawful for an OC to resolve, excuse me, when electing a committee, to reduce the numbers that somewhere less than 12, but more than 3. And there's cases, including one called McCready, that stand for that proposition. So just to repeat, or bullet point that, maximum of 12, but an OC can resolve to have less currently. The new changes say that a committee has a maximum of 7, but it can resolve to have more than 7, up to 12. So it's really ended up the same result. Rather, you currently it's 12 and you can come down. With the amendment, it's 7, but you can go up. So in the event, you probably end in the same place.
Okay, wonderful. Excellent. Well, we have gone a little bit over, so we might leave it there, although we have got other questions that have been submitted. If you did happen to submit a question and we haven't had a chance to get to it today, we had lots of questions come in, so I'm really sorry. But just submit it via our Ask a Strata question page on the LookUpStrata site. I tried to copy some of them down, but I have missed a few because we had so much discussion going on in the chat. Before we go, I'd just like to say a really big thank you, Tim, for joining us today, for taking the time out. I know there's a lot of time that goes into preparation of these sessions, plus the hour that we've taken out of your day today. So thank you.
Oh, no, well, thanks for the opportunity. That's my pleasure and privilege, Nikki. It sounds like you're going to give me homework that distends beyond the hour today, but that's okay. It'd be my honour. Thank you.
Thank you very much. If that's okay, that would be wonderful. Okay, at the end of every session, we like to ask our guests to share some exciting news that's happening. And Tim, you've always got exciting news with Bugden, Allen Graham Lawyers. So if you've got something that you'd like to mention to us today.
Well, knowing that you'd put me in that position, I thought I'd better do something that's exciting to tell everybody. So we went and decided that we'd open up an office in Perth. So they'll be your neighbours, Nikki. That's going to commence operation in early January. We already do a lot of work in Perth, and my partners Gary Bugden and Michael Allen have certainly advised government in respect to various things. We're doing some exciting developments over there. So it just seemed to be the irresistible organic progression to open an office, and that will be spearheaded by Sean McFarlane, who will join the firm as a partner. And Sean, he's currently in private practice, but immediately before that, he was the advisor of the minister who basically drafted the strata laws, the new strata laws that you got in the last year or two. So he's certainly all across that, and we're very excited about Sean joining us in the office opening. We'll have to get across and see you at some point.
Well, yeah, definitely. When we let you through, you're welcome to come over.
When we can get in, yes, yeah, that's right. Yeah.
For those who don't know, I'm actually located over in Perth in WA, so I was very happy to hear the news, and yeah, I'm certain that we'll have a webinar at some point covering the WA legislation with Sean, I'd imagine. So we'll certainly let everyone know when that happens. So thanks very much, Tim. Thank you everyone for joining us. We had fantastic numbers today. I think we had about 350 register, and I think there are about 250 or more than that were actually sitting in on the session today. So we really appreciate that you've taken the time to listen. And I understand why you attend these sessions, because Tim's got so much great information to share, and he shares it so freely and easily. So thank you very much, and I'm sure we'll catch you next time.
Too kind, Nikki, but thank you so much.
Okay, thank you. Goodbye.
Bye now.